on the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
Aloha, welcome back. I'm Ben Carroll. This is BLAW200, the legal environment of business. Well, we've been talking about business entities. Last time we wrapped up corporations, so we looked at some of the things affecting corporations, looked a little bit at the financing, we looked at antitrust provisions, Securities and Exchange Commission, that sort of thing, and very briefly talked about some of the concerns with corporate responsibility. And today we're going to get into what the area we call administrative law. So we'll be looking at various rules and regulations in the departments and agencies that promulgate them. But first, let's take a look at our review and make sure that we've got corporations down pat. Okay, so what do we mean by double taxation, and can this be avoided? Well, double taxation, again, you recall, is one of the things that's kind of the drawbacks of the corporate form. And that's why we have all of these new entities that are attempting to avoid that. But what do we actually mean when we say something's being double taxed? Well, when the money comes into the corporation files an income tax. It is its own entity, so there's a corporate income, there's a corporate tax, and they pay that on the profits. Now, if they send those profits out to a portion of those out to the shareholders, to the owners, then when the owners receive those, they also pay taxes on their own individual income tax. So the same money has then been taxed twice. Now, can we avoid that? Well, what gets taxed the second time are the dividends. So if you don't pay out the dividends, then you can certainly delay that tax until perhaps gains tax. But there are some other ways where you can transmit the money in a fashion that isn't a dividend and is not taxable. So we talked a little bit about those. Those might include paying your shareholder that is also a lessor or is also an employee, or you're giving them back capital in one sense. So there are some ways that you can attempt to reduce that second tax bite. But these, of course, the IRS is going to look at very carefully to be sure you're doing it right and you're not simply avoiding taxation illegally. And, of course, the other way would be to comply with and file and operate your corporation as an S corporation, subchapter S corporation, which would avoid the bulk of that taxation. Okay, what's the difference between fraud and insider trading, and who enforces this? Well, fraud's something we've looked at in several sessions. So fraud would be misrepresenting the condition of the company, misrepresenting something in your filings about the corporation. What is insider trading? Well, that's not misinformation, that's misuse of what they hope is good information. So that's using information that's not available to the general public. So the idea is that in a publicly traded company, everybody should be on reasonably equal footing. And so if you are using information that's been provided from inside, then that's improper, gives you an unfair advantage. So what kind of information might that be? Well, anything that's going to affect the stock price certainly is going to be information that's valuable to know whether to buy more stock or sell the stock you have. So it could be something good that's going to happen and raise the value of that stock, or it could be something that may damage or be detrimental to the value, and so you would want to unload or exchange your stock. So again, insider trading is improper, and we've seen a number of well-known folks get wrapped up in that. Okay, what is the SEC and what does it do, and how about the FTC? Okay, well, the SEC is the Securities and Exchange Commission. It's been around a long time, and what does it do? It regulates essentially the exchange or the sale of securities. And what are securities? They include corporate stocks and bonds. So this is the agency that takes care of brokers, makes sure that the people that are involved with stock transactions are doing it properly and disclosing what they should. So also would cover mutual funds, financial advisors, all of the folks basically that are going to be involved with publicly traded stocks. How about the FTC? Well, that's the Federal Trade Commission, and they're going to be concerned with the antitrust and monopoly provisions of the Sherman Act and the Robinson-Patman and Clayton Act. So that's the one that's going to be looking at the mergers and those type of arrangements. Okay, what's the difference between horizontal, vertical, and conglomerate mergers? And does the government care about mergers? Okay, you recalled we had a few pictures on this. So horizontal means we are dealing with people that are essentially in the same business, competitors usually. For example, we looked at airlines, we looked at automobile manufacturers, and these are folks that are essentially combining forces, and they're in the same business. They're selling the same product or service. Okay. How about a vertical merger? Well, this is where somebody's in kind of that production chain. So we looked at if Apple were to buy a chip manufacturer or a software producer or something, so that that's a part of their production chain, and so they would have, in essence, a captive producer of that now in their system. And a conglomerate would be essentially unrelated, not a competitor and not a supplier. So in many instances, kind of completely unrelated companies that would get together. Now, does the government care? You bet. And mostly because when we do these certain combinations, we may be limiting competition, particularly if competitors are getting together, or we may be in the process of creating some kind of monopoly, and the government's going to look carefully to make sure that trade, interstate commerce is not affected adversely. Why are we concerned about monopolies, and what act prohibits monopolies in interstate commerce? Well, this is the Sherman Antitrust Act, and the Clayton Act prohibits the mergers. But why are we concerned about monopolies? Well, if someone gains a monopoly power in a particular industry, then they essentially can dictate prices, etc. So we're concerned if someone becomes that powerful because they can now destroy the competition, raise prices, etc. So we're concerned that this affects trade, restrains trade, and so the government's going to get involved and prevent the merger or prevent the other acts. Now, corporate social responsibility. And this has actually become common enough in discussions that you may see the acronym CSR and discussions about this. So are we all agreed that this is a good thing? What is it, and where do we stand on it? Well, corporate social responsibility is the idea that a corporation has obligations or responsibilities over and above simply the economic value. So again, we looked at it, and everybody's pretty much agreed you're supposed to be making profits because you are to benefit your owners, your shareholders, and you have to comply with the law. So certainly have legal and economic imperatives that every corporation, virtually everybody, admits that that's proper. Now, we have some folks like Milton Friedman and some other economists that say, that's it, that's enough. In other words, when these folks would talk about corporate ethics, they would say a corporation is ethical if it does not break the law and it takes care of its shareholders. That's enough, that's sufficient. Others people would add on some additional responsibilities to other stakeholders. In other words, in increasing the number of people that we consider that the corporation should benefit. So there's a position that it should benefit more than its shareholders and even its employees, etc. It should be benefiting the community in which it lives, the country, etc., society. And so on top of the legal and the economic, we might say ethical is a higher thing. It's more than, and it's an expectation to act ethically and properly over and above whether or not it's legal. And then some would even add on top of that kind of a philanthropic, good corporate citizen. And what does that mean? What types of things should the corporation be doing? So we talk about green corporations. We talk about corporations that give back to the community, involved in charities, and there's a number of different ways that the corporation could show that. So the question really is where you come down on this. Is that something the corporation should be doing? And we find some corporations, even though they may not have some altruistic, and again, Friedman says, how can a corporation be altruistic? But they may decide that they at least want to appear to be doing this because that will attract a certain kind of shareholder, be good publicity, etc. So this is certainly an area where there are a lot of opinions and things are in a flux, but there's no real consensus, although more and more people are concerned about what the corporation is doing and its impact. So it seems like we're kind of moving toward this as being desirable. Okay, well, we are going to look at administrative law, and this is a big, big area. When we talk about administrative law, we're talking about administrative departments and agencies. So we'll be looking at where the agencies get their authority, what their functions are. We'll be looking at government regulation. We'll be looking at court review. And finally, we'll look at the Open Meetings and Freedom of Information Act that has to do with this area of the law. So it's a big area. When we very first started talking about where law comes from, you recall we talked about executive, legislative, and judicial. And this is the area that we think of as being in the executive branch. So we don't think of executive orders necessarily as being the main source of law coming out of that branch. We think of the rules and regulations from departments and agencies. Okay, so when we talk about administrative law, also called regulatory law because these departments and agencies do a lot of the regulation. Again, they produce rules and regulations that cover a broad area of the law. There are many, many departments and agencies. Many of them are part of the executive branch, so obviously things like Department of Health and Human Services, Department of Defense, etc., very clearly part of the executive branch, but there are also some hybrid agencies and some independent agencies as well. But we'll talk about them really at this point all together. Okay, as I said, this is a great big area of the law. You're affected by departments and agencies every day. And if you remember some of the charts we had earlier on when we were looking at where law came from, you can see that we have these at federal, state, and local level. And so there are going to be hundreds of departments and agencies, and they're going to be named all different things. So it won't necessarily be called Environmental Protection Agency. We may have Atomic Energy Commission. We may have things called Council, Board, any number of different names. So we're going to have to look carefully at these when we're in an area of the law to make sure where the authority for this particular body comes from. Is it in fact been given authority so that we would consider it to be an agency, regardless of what the title of it is. Okay, so we need to look at agency functions, and we've divided these up because agencies and departments, and when I say agencies, we're going to be including departments, so I'll just use that as a meaning both. When we talk about agencies, we know they have a power to create rules and regulations. That's the kind of law that comes out of agencies. And they do this in a way that looks very similar to the legislature. And so we're going to use the word quasi, which means Latin for looks like or sort of like. And so there's a function the agencies have that we would call quasi-legislative. And so that means that they are acting like a legislature does. So what does a legislature do? Well, the legislature passes statutes. So that's the kind of law that comes out of the legislature. And we've looked at that. We know that they hold hearings, they have committee reports, they let the public talk to the agent, talk about whether the law is a good thing. And so that is what a legislature does, and the agencies do something very similar. So they act like a legislature when they're passing their rules and regulations. And again, it looks very similar to what the legislature does. So they may have an opportunity for people to say what you think about the proposed rule and regulation, just like the legislature does in passing a statute. And we call that notice and comment because it's giving notice that we're going to pass this regulation and asking for public comment. So again, a little bit less formal than what the legislature does. Another difference is this rulemaking can happen all the time, not just when Congress or the legislature is in session, but they can be passing rules and regulations all the time. So we tend not to be paying as much attention to these departments and agencies. Number one, there's a whole array of them. They're not in the public eye as much, and they're not in a compact period of time as when Congress or the legislature is in session. So, but they do look like, when they're making rules and regulations, they look like an informal version of what the legislature does. So that's why we call that a quasi-legislative function of a department or an agency. Okay. Now, why do we allow them to make rules? Well, because the legislature is the body that's meant to make statutes, make law under the Constitution, but it doesn't really have the time or expertise to deal in these various subjects. And so it will use departments and agencies because they can be more flexible. They can develop sophisticated and technically competent staff to produce rules and regulations. And again, the volume of rules and regulations is massive compared to statutes, obviously, because there's so many areas that are being dealt with and in detail. Okay, another thing that can happen through the rulemaking is there can be an adoption of it's sort of like uniform laws, but they can be implemented much easier. And so we have the Center for Disease Control can come up with standards for sanitation, or we can promote national building codes, that sort of thing. And another thing that is frequent in the rulemaking is we want to limit, or at least the agencies want to limit, the opportunities for the court to get involved. Because again, this is a more informal process. Even though these rules and regulations do have the force of law, we tend to defer, and we'll talk about that a little more, but we tend to defer to departments and agencies. They're considered to have expertise in their area because, of course, they're dealing with a much smaller area. They're making rules and regulations in a much more compact, narrow area than the legislature does. Okay, well, we have another function that the same departments and agencies do. They have the opportunity to interpret the rules and regulations, and if there's a dispute about the interpretation or application, then they will be involved in adjudicating that, in having a hearing about that. Now, you can imagine this sort of looks like what a court does. So we're going to call that a quasi-judicial function that the department or agency has, whereas it does sort of what a court would do. It would interpret the rules and regulations, and it would have a hearing if there's a dispute about them, and it would issue a decision. So this again looks like what a court does, a little less formal, as with the legislative function. It's less formal, but bears a striking resemblance to what happens in court. So again, we call that quasi-judicial. So if someone disagrees with what the agency's decided, then they will hold a hearing on that matter. Now, the hearing is going to be held by an officer of the department and agency. On the federal level, we typically call this an ALJ, an administrative law judge. Hawaii and many states would call the person a hearings officer, although some states would call it administrative law judge as well. But again, you can see even the terminology, whether we call it a hearings officer or an administrative law judge, very clearly this starts to look like we're in court. And although the rules of evidence are more limited and it's more flexible in general, again, quasi-judicial looks like going to court. That's another function of a department and an agency. And again, this is the same agency that made the rules is now interpreting and applying the rules. Okay, in addition to making the rules and interpreting the rules, the departments and agencies are going to enforce the rules. So they have executive power to prosecute offenders, to have fines, to investigate as well. So we would call this executive or administrative power, and that's what we tend to think kind of lodges in the executive branch is the enforcement and application of things. So the same departments and agencies are going to be involved in investigating claims and complaints and issues, and they have the power to discipline, fine, sanction, etc. Okay, so we have subpoena power, fines, orders. They have what we call a cease and desist order. So if something is being done that's improper, the department or agency will issue a cease and desist. And this looks quite a bit like the injunctive relief, the injunctions or temporary restraining orders that come out of a court. Okay, now where do the departments and agencies get the power? Well, the Constitution gives the power of lawmaking to the legislature. And the legislature is able to delegate this power to the departments and agencies. And we call this act that does that the Enabling Act or the Authority Act. So this gives the power that the legislature has to deal with a particular area over to a department and agency. So one example might be workers' compensation. We have a workers' compensation statute, and as you recall, that's a state statute. There are federal compensation acts for federal workers as well. And so we have a statute, and we delegate the power to apply and deal with the statute to a particular department or agency. So in Hawaii, that would be the Department of Labor and Industrial Relations. And so they are given power to handle workers' compensation cases. Now, the statute gives broad authority, but there are going to be rules and regulations that the department or agency will make as to the nitty-gritty of how that's going to be handled. Okay, as we said, this delegation is not mentioned in the Constitution. The power is given to the legislature to make law, but it has been found proper that the legislature can, in fact, delegate this to the departments and agencies. And we've talked about the reasons why, because departments and agencies can develop expertise, deal with these matters. And so, again, typically they are given rule-making power. So the Enabling or Authority Act passed by Congress or the legislature would say this department and agency can make rules and regulations consistent with this act. So they are giving the power to the agency to implement the statute, because the statute would be broad, and how to file and the nitty-gritty, again, the details would not necessarily be there, and the agency itself would be able to develop those rules. Now, not every agency has rulemaking power, but many, many of them do. Okay, again, this Enabling Act, also called the Authority Act, it's going to be specific to the particular area of the law, so it's going to give this department or agency specific authority to deal with a particular statute, a particular type of case. And so each department and agency would have essentially its own Enabling Act, its own Authority Act, wherein it's delegated that power. So it would give the powers and duties, how it's organized, would explain where the funding comes from, would often indicate what the basis for review, judicial review of the agency activity is. And we'll talk about that because judicial review typically does not come to until the very end of an agency process. It could come a little earlier for due process concerns, but typically the agency decision is not going to be reviewed till afterwards. And so there may be an indication of what types of things could be reviewed by the court. Again, some states in their constitutions would provide for particular departments and agencies. Okay, now these various functions, and we can see already that it's pretty powerful because we've got a department or agency making rules, interpreting rules, enforcing rules, holding hearings, issues decisions, and in all of these aspects, they obviously need to be in compliance with their Authority Act. In other words, they've been given a certain amount of authority. They can't have any more authority than the legislature had, but the legislature can delegate that. But it's going to be specific what they're authorized to do. And so they need to follow that. In addition, there are some concerns with due process and constitutional limitations that we want our departments and agencies to follow as well. So we have another set of legislation that we call the Procedure Act. So there's going to be a Federal Administrative Procedure Act, FAPA, and there would be a Hawaii Administrative Procedure Act, HAPA. And there can be, various states may not use that terminology, but it is quite common that you would call it the whatever Administrative Procedure Act. And so this is another set of rules that would apply to departments and agencies that explain how the departments and agencies should operate. Okay, now these govern all aspects of the agency, so it would talk about how they're set up, it would talk about how they make rules, and it would talk about how they hold hearings, how they issue decisions, that sort of thing. Now, generally, the Administrative Procedure Act is going to cover all of the departments and agencies. So it's going to set some basic standards, some basic due process requirements, and every agency needs to follow those bare minimums. Now, they can obviously make their own procedural rules if they are consistent with the bare minimum, kind of the floor that the Procedure Act provides. And again, it will provide that people get notice of hearings. It will provide that they can present evidence, all of those sorts of things that we consider to be kind of basic due process. And that's required of all departments and agencies, so all of them would be subject to the Administrative Procedure Act. Now, so they've got both the Enabling Act that they have to follow that gives them their specific authority, so that's individual to them, and they have the Administrative Procedure Act that they have to follow along with other departments and agencies. So the legislature has kind of put those constraints and those restrictions on how the departments and agencies can operate. Now, various departments and agencies will develop their own rules about how to do things. And as we said earlier, they can be quite flexible because they're dealing with all different kinds of issues, all different areas of the law. And so they are provided quite a bit of flexibility, and that's a good thing so that they can deal with their particular area and develop expertise there. So the procedures that happen in departments and agencies will differ considerably. Again, they do need to follow the basic requirements of the Administrative Procedure Act and their own Enabling Act, but as long as they're within that authority and following those proper procedures, they can develop their own system in different ways. So, for example, a department or agency might have its own appeal process within the department or agency. And, for example, in Hawaii, workers' compensation, there is a workers' compensation appeal board. So if you get a decision from your department or agency, you can appeal right inside the agency up to an appeals board. That may not be the case in other agencies where simply the director or the head of the agency will issue a decision based on what an individual hearings officer said, and that will be the end of it. So the processes inside the various departments and agencies can differ. But again, as long as it complies with its own Enabling Act and the Administrative Procedure Act, it's good to go. Now, at the end of the agency process, if you feel like the agency has done something wrong, violated rights, improperly done the law, exceeded its authority, something very major and basic, then you can appeal that to court. So you can appeal to the lowest level of the one of the lower levels to a trial court. So in Hawaii, you would appeal an agency decision to the circuit court, and in the federal system, you would go to the United States District Court, and the statutes would tell you how you can do that appeal. Now, the appeal is generally going to be looking at whether or not the agency followed a proper procedure and whether or not it has violated, gone outside its authority or something of that nature. It's not really a second chance to get a second opinion, okay, because the court is not going to second guess a department and agency. The other thing is you have to go all the way through your agency process. You can't, even if you don't trust the agency, you already know what the agency is going to decide, you still need to go through that process. And we call that exhaustion of administrative remedies. And what that means is that you have to fully go through and allow the agency to go all the way to give a final decision to you before you're able to go to court. So there's a lot of deference to the agency. And we call that exhaustion of remedies. And some of the processes are long enough that exhaustion kind of sounds like an accurate description of that. But we simply mean you have to complete the agency process. Okay. Now, there are some exceptions, some rare instances where the agency may allow you to short-circuit the agency process. And the one I'm familiar with is the EEOC that we've talked about, the Equal Employment Opportunities Commission. And they handle many, many discrimination cases. It may be that after looking at your case, they have determined they know how that's going to come out. So they've had enough of this kind of cases that it's very predictable that even at the end of the agency process, we pretty much know what the decision is going to be. And in that instance, the agency could issue to you kind of a free pass to go to court. And we call that a right to sue letter. And that's a permission to short-circuit or not go through the rest of the agency process to the end, but go directly, and you are able to, at that point, file to have the agency decision looked at by the court. But unless you have that right to sue letter, then you need to exhaust your remedies. You need to go through the process till the end, and you get a final decision from the department or agency. Okay, now what's the scope of review? As I indicated, that's pretty limited. So the court's going to give a lot of deference to the agency decision, and the reason they do that is because the agencies are considered to be the experts. And when you think about it, why wouldn't they be? Because here we have a department or agency. It has made the rules. It gets to interpret the rules. It gets to apply the rules. So why wouldn't they be the experts? Again, they may be dealing with a fairly narrow area. They have staff that they've had a long time. They get the experts, the consultants, whatever. So they are meant to develop this expertise and to use that in their decisions. So the courts do tend to give a lot of deference. And again, the statutes will indicate when and what you can have reviewed by the court. But it's fairly limited, so you have to essentially show that something very wrong has happened. The court is not going to give you a new trial, so to speak, and to see what the court thinks about it. They're going to simply see that the agency has properly fulfilled its responsibilities. Okay, so it's not an independent review. So we did talk briefly before about de novo review when we were talking about appellate courts. In other words, looking at something fresh as if it's new. That's not happening here. So again, we'll look and make sure the procedure's followed. Of course, if the agency has operated outside its authority, outside its enabling act, or it hasn't given you the protections that it's required to, due process, etc., under the Administrative Procedure Act, then you may have a good claim. But if you simply think they're wrong, you can't show a particular violation, probably the review is not going to be successful for you. Okay. Now you can see that departments and agencies, although they're fairly small, some of them are obscure, they have an awful lot of power here. because they are doing all of these functions together. They're mixing together executive power, they're mixing together judicial power, they're mixing together legislative power, and a single department and agency is doing all of these different things. And that's kind of concerned people because it's a lot of power vested in small department or agency. So there were questions that this is some kind of a hybrid thing, and you'll actually probably see in some of the readings people talk about this as the fourth branch of government because it does seem to have a whole lot of power residing in these departments and agencies. But it's been pretty well resolved for quite a while that in fact departments and agencies are able to operate this way. And we do have some checks and balances on them as we've started to talk about already. But even though the departments and agencies seem to have the powers of the executive, legislative, and judicial branches, those actual branches also have control over the departments and agencies. So we've already talked a little bit about the power that the legislature has in the Enabling Act and the Procedure Act, but there's some more direct power they have over what the agencies are doing as well. So we talked about the direct control of the legislation, but the legislature also may restructure it. They can change decision-making procedures, they can reduce the funding, and they are involved in the appointment of agency head. So these are very distinctive and direct applications where if the department and agency isn't performing the way that the legislature believes it should, they have some direct input into that. So one of these, of course, is the funding. So the legislature is the body that funds department and agencies, and they can simply stop the money or reduce the money or do other things with the funding, put conditions on it. So, of course, this is very powerful control. In addition, certainly the department heads are members of cabinet. So these are folks that the legislature may have the right to approve. So even though they're appointed by the executive, then the legislature has the power to approve them. And so we see Senate approval of cabinet members, that sort of thing. So there's certainly this power as well. So in addition to the kind of the broader construct of setting up the departments and agencies through statute, which the legislature does, it also has the power of the purse, which is obviously very powerful. And it does have the right to approve at least the officers, the cabinet level heads of those departments. And again, this is very powerful as well. In addition to the legislative control, we have control by the executive. So in most of these instances, the higher level departments and agencies, the executive is going to be actually appointing these people. The other possibilities are executive order, and sometimes the legislature gives the executive power to reorganize, and these are also powerful. So we don't use the executive order much. You recall when we're talking about the powers of the branches, executive orders typically were used, for the most part, we thought of as for emergencies when the legislature couldn't meet. But executive orders can also be used in certain instances to direct how the departments and agencies function. So the executive also has some controls over departments and agencies. And of course, we've talked about judicial control in reviewing the decisions. And as we said, this is generally done at the end of the exhaustion of the administrative process. So generally, the court's going to look at it at the end. But of course, if something is happening improper that needs fixing right now, then there's obviously injunctive relief and other possibilities. But as we've talked about, generally the judiciary is going to give a lot of deference, and they're going to wait till the administrative process is finished before they're going to interfere. Okay, well, you can see that this way of operating these departments and agencies is rather different from the other branches of government. And as we just indicated, we sometimes talk about it being the fourth branch. But what's kind of interesting is this way of rulemaking, this way of making law and handling law seems a little unusual to us in the common law field, but in many other areas of the world, this looks very common to them because this is much more like the way that civil law jurisdictions work. So, for example, Europe, South America, etc. So if you look at some of these similarities, you can see there are a lot of parallels. So the administrative law area looks at codes, so we're not so much concerned with the case precedent, and we talked about that the judiciary doesn't get involved as much. And the other things are that inquisitorial versus adversary. So when we talked about the court process, you recall that we have an adversary system where both sides present, and it's kind of like a battle. You know, it's a trial by combat between the opposing sides. And again, this way of holding trials is much different in civil law jurisdictions. It's more the judge doing the questioning, that sort of thing, as opposed to the parties battling it out. So we call that inquisitorial as opposed to adversarial. And that's very typical of the administrative process. And then finally, the whole idea of all of these functions being combined together seems a little bit strange to us because of our history, where we have this very distinct separation of the branches and separation of the powers. But it's much more common in civil law countries where they're used to having single bodies handle more matters in an administrative fashion as opposed to the way we do it in our system. Okay, another feature of agencies is a lot of records. So they keep a lot of paperwork, and people may be concerned what sort of things are being gathered about my business, about myself, etc. In the past, there have been instances where it appeared that the agencies were keeping this private, even from the people that were involved in the investigation or whatever. So you could be investigated and didn't know what was being handled. This was a concern, and so Congress has passed a number of laws to make this more open, to make what's going on more accessible. Because again, we have many, many departments and agencies not nearly as visible as, for example, when the legislature's in session and we have a good idea what's being looked at and how it's being handled. Now, unfortunately, a lot of exceptions to these statutes, but they are an attempt to provide protection to individuals if information is being gathered about them. Okay, so one of the main ones is the Freedom of Information Act. And there are very similar state laws, often called different things, records laws, etc. But the Federal Freedom of Information Act, well known, it allows people to discover what an agency has collected about them. So, and it has to be made available to you in a useful format. So originally the problem with the Freedom of Information Act is that it could be very expensive if you had to pay for copying of various records. And now the agencies have to give that to you in an electronic usable format. Now, as you can imagine, a lot of exceptions to what's available in Freedom of Information. And so you can see here that there's exceptions for national defense, personnel files, records required to be kept secret, trade secrets, law enforcement records, and internal decision making. And you can also imagine that after 9/11 and Patriot Act, etc., that claims of security, etc., are very frequently used. So, but the Freedom of Information Act is very powerful in obtaining records that pertain to you, and so it is very pretty effective in finding out what the government is investigating and doing. Again, riddled with exceptions, but in many instances you would not be covered by something considered to be national defense or security, etc. Okay, another important act is what we call the Open Meetings Act, and frequently that's also called the Sunshine Act. And this basically means that departments and agencies need to be public about when their meetings are and what they're going to be dealing with. So now again, there are a number of exceptions where meetings can be held without this kind of notice, and they're not open to the public. Now, if you think about it, there obviously are certain kinds of things that would be part of a department or agency meeting that shouldn't be public. So what would that look like? Well, again, personnel matters, If the department or agency is consulting with an attorney general or a lawyer about something happening to the agency, either being sued or not sued, we're talking attorney-client privilege, that sort of thing. So those sorts of things would be closed. And this happens in other types of meetings as well. Sometimes we call that an executive session. So that particular part of the meeting is not public. That can be private to deal with that particular matter, even if the rest of the meeting is open. But these Sunshine Meeting, Open Meetings Acts are meant to make it more visible what the department and agencies are doing to allow people to take part and participate and see what the agency is doing. So it has to be at reasonable times, there has to be notice, etc. And occasionally we'll see in the paper a meeting's been canceled because the notice was not given out in time for people to be able to attend. Obviously, there's the intent that you not hold the meetings in obscure places in the middle of the night, that sort of thing. Okay, and Federal Privacy Act. This is actually the kind of the reverse, and this means that the information that departments and agencies get, although they may have to show it to you, they need to keep some of it private from other agencies. So they can't willy-nilly share this once one agency have it and distribute it all different places. So, okay, well, this is kind of a look at general administrative law. We will be looking at some other regulations next time in the consumer area, but this is very highly regulated types of businesses. You can see that there are many of these businesses that will be regulated considerably more than the norm. So we've already talked about securities and employment, trademark, and we'll be looking at some of the rest of these next time as well. But what we'd like to do now is actually to talk to some people about how the administrative agencies work. So why don't we do that and get a little more insight into the administrative law area. Aloha, we're here with Professor J, Susan Jaworski, and we'll be talking a little bit about admin law. So, Susan, would you let people know a little bit more about your legal background in this area?
Sure, Ben. I am an attorney, as you know. I'm also the paralegal program director and teach a little bit about admin law to my Law 101 class. But maybe more relevant for this discussion, I worked at the legislature for 19 years. So I know how the legislative part of the system works and how it plays into the admin rules part. That's an excellent question, because if you look at an admin rule and you look at a statute, they look pretty alike. They look as though they talk the same language, they're speaking about the same things. So students do say, why isn't it in the statute? And there's two reasons for that, Ben. One is the issue of time, and the other is the issue of knowledge. Getting back to the issue of time, people don't realize that the Hawaii State Legislature is only in session for 60 working days. And during this 60 working day period, they hear over, or they get introduced 3,000 bills. So you can imagine that there's such an overwhelming amount of work there that they can't possibly hear the bills in as great a detail as they would like. In fact, there's only about 10% of all the bills that are introduced every year that become law. It's because the process is time-consuming. It's time-consuming for a reason, to make sure that the legislators have the ability to hear everything that they need to about the bill. For example, there are at least 3 readings in each house. There's at least 1 hearing. Then the bill crosses over to the other house. There's 3 readings there. There's at least 1 hearing. If the bill is disagreed to by both houses, it goes into conference. You can see why most bills that come in January don't come out of the hopper until May. Now, in comparison, executive agencies are open year-round. They're not limited to 60 working days, and they also have a process that's much more streamlined than the legislative process. The second issue is the issue of knowledge. The legislators are generalists. When they are elected, they're elected because we, the people, think that they're going to represent us well at the legislature. They're not elected because they're great on healthcare financing or cable television regulation. So they do their best to come up with the overall policy decisions, but they're not really equipped to drill down to the details that you need to actually implement the laws. In contrast, the executive agencies are. The people in those agencies specialize in these areas, cable TV regulation, coffee regulation, etc. And so they are more knowledgeable about the specific areas that need to have regulation so that the process will go through smoothly.
So in a sense, we're looking at what we might consider to be experts in these particular areas.
Yes, I think that's an accurate way to put it. And the legislators are happy to pass that information off. This doesn't mean that they abandoned their responsibilities. In fact, the administrative rules can't be adopted unless three things happen first. First, it has to be adopted in conformance with HAPA, which I know your students have heard about. Second,
so that's Chapter 91
of the Hawaii Revised Statutes, the Hawaii Administrative Procedures Act. Second, they have to have a statute that has been adopted by the legislature that authorizes the executive agency to adopt rules. They can't just adopt them, they need to be authorized. Third, the legislature has to adopt a statute that says what the topic is that they can adopt the rules on. Now, sometimes that authorization and implementation statute is the same statute, and other times it'll say that the Department of Health, for instance, is authorized to adopt rules in this section, but the rules that it's adopting occur much later in that chapter.
We sometimes refer to that also as the Enabling Act, but that's the act that gives the authority to the agency.
Right, and so the legislature isn't just abandoning their responsibility, they're actually turning it over specifically to the experts. Well, the constraints are the three statutes. First of all, the procedure has to be adopted according to the HAPA statute, which we talked about, and it has to be within the scope of what the statute says. For instance, if the statute authorized the Department of Health to adopt rules relating to flu shots, mandatory flu shots, that statute can't be used to require mandatory vaccines of another type. The rule has to fit into what was authorized by the statute. And if it doesn't, there's going to be a problem with trying to make that implemented. And in fact, it can be even challenged in court.
Okay. Do you have some other examples of how that works?
I do, because people are sometimes surprised at how little statutory material there is and how much material there has to be for the executive agency. Here's an example on Kona coffee. This is a short 3-line section of the statute that authorizes the Department of Agriculture to make rules, and I'm going to read it, defining grades and grade labeling requirements of agricultural commodities and standard containers for the packing of particular agricultural commodities. That's it. There's nothing in here that even mentions the word Kona coffee, yet this is clearly encompassed by the statute. So when the Department of Ag gets this short 3 lines, they have to come up with a whole lot of administrative rules just for that one part of the sentence. It didn't even mention Kona coffee. This is actually Chapter 143, Standards for Coffee. It's 19 pages long and has incredible detail. For example, it has one, 2, 3, 4, 5, 6 pages just of definitions. And let me tell you the kind of detail they provide once it gets down to the regulation. This is Section 4.143.4. It's entitled Standards for Grades of Cherry Coffee Grown in the Geographic Region of Kona. Hawaii No. 1 cherry coffee consists of cherries which are firm, mature, well-colored, not excessively dirty, and free from fermentation, decay, raisined cherries, dieback cherries, black beans, floaters, foreign materials, and injury caused by disease, insects, or mechanical or other means. Not more than a total of 2% by weight of the cherries in any one lot may fail to meet the requirements of this grade, and not more than 1/8 of 1% by weight shall be allowed for foreign materials. Then there's another section that talks about Hawaiian cherry coffee No. 2. There are literally 19 pages that implement this tiny little section. Well, that's a really good question. It's two. Let me break it down into two. The first is, what if they adopt rules that are outside the scope of the statute? First of all, you would expect that experienced administrative staff wouldn't do that, but if they do, that administrative rule is void. It doesn't have any effect because it was never authorized by the legislature. So it would be void ab initio, void from the start. But let's say they adopted the rule, and then the legislature went and amended the statute, or even repealed it. Then the administrative agency really needs to be on its toes and be constantly monitoring what happens at the legislature, at least at the end of the session, to see if any of the statutes have been amended or repealed. Because if the statute was repealed, the rule is automatically gone because there's nothing supporting it anymore. If the rule was amended, then it's the job of the executive agency to go in and see if the rule's still good, is it still authorized under the new language, and if it's not, the part that's not authorized is gone, but maybe the rest of it's there. And of course, the best option then is to go in and amend the whole rule so that it is all in conformance with the new statute. Well, first, I would make sure, if it were me, that I would go to the agency and that they understand this. Because being that the penalty for doing this means their whole rule is gone, I would hope they wouldn't be intransigent about this. But if not, you can take this to the courts. Because if the executive agency is trying to adopt a rule that's not in conformance with the legislature, your remedy is with the courts. And I think the courts would be very sensitive to the executive agency's duty to follow the legislative statutes. You know, I went to the Supreme Court Law Library earlier this semester, and if you had stretched out all the statutes, maybe they're on a shelf this big. For the administrative rules, 9 shelves of binders. And not all of the statutes have admin rules. The criminal law doesn't have admin rules. So that's an incredible proportion of expanded paper that the executive branch has to do for the legislative branch. So bravo to the people who do that hard work, because it is necessary to have the government function.
Okay. Well, I hope that was useful to you. Get a little more insight. Again, administrative law covers a wide variety of departments and agencies in a whole bunch of different areas that affect us both as individual and businesses. And there is also additional information, as always, on our website. So please take a look at that. There's some more material on some of the different areas covered by different departments and agencies, as well as kind of a alphabet soup of the we talked about the hundreds of agencies, so there's some introduction to what those are. Okay, and as indicated a little bit earlier, we're going to be dealing with the consumer protection area next time, so this will be hopefully of personal interest to you. We may talk also a little bit about landlord and tenant and some of those areas that will a little bit on the outside of business law, but which should be of use to you. So until next time, this has been Carol. Aloha.